Hey everyone, this is the parental rights here in Douglas, USD 396. There are some words to know that you need to be aware of. That's IDEA, Individuals with Disabilities Education Act, which is a federal law. FAPE, which is Free Appropriate Public Education. KESA, Kansas Education Systems Accreditation. State statute. That state statute is Special Education for Exceptional Children Act, an IEP, Individualized Education Program, and an LEA is a local educational agency. And a parent is classified as a natural parent, an adoptive parent, a person acting as a parent, a legal guardian, an officially appointed educational advocate, or a foster parent. In regards to parental rights, parents have the right to participate in all decisions regarding their child's IEP, along with being a part of the IEP team. They need to be provided with a notice ahead of time of all the meetings taking place regarding eligibility, evaluation, reevaluation, IEP development, and any provision of a FAPE to ensure they have the change to attend in the meetings. Parent rights should be provided at least one time a school year. Upon the referral of a parent request or initial evaluation, there should also be the parental rights given. The first formal complaint in a school year, upon a disciplinary removal from school, or upon a parent's request, they should be given the parental rights contract or notice. Schools must do their best to make sure all parents understand and can interpret the information being provided, and they must have the right to decisions and upbringing of the students. It is suggested that parents be given a Parents' Bill of Rights, which states what the parents are capable of doing, what they can and can't do, what they should be doing, to encourage and engage parents to be partners in their child's education. The state statute parental requirements, parents must give informed consent. The consent must be informed, and this needs to be based off the parent being fully informed of the information which consent is being sought. They agree to what is being proposed. They understand this can be revoked at any time, but if they do revoke, that is not retroactive, and it must be presented in their native language. The informed consent must be in their native language. LEA agency may still evaluate without parental consent. It is subject to the parent's rights under provisions for administrative appeals, reviews, civil actions, due process timelines, and status of our child during the proceedings under the IDEA. Parents must make sure children are attending school to receive the services their IEP has listed. If they are privately seeking these services, if that's an option, they still need to make sure that their students are still receiving the services. Parent and family engagement is important in order for students to be successful, and attendance may begin as early as age 3. IEP meeting notices. Schools must make sure that one or both parents are present during an IEP meeting. The notice should be given 10 days in advance and state that parents are invited to attend the meeting. It is encouraged that they attend the meeting, at least one of the two parents, if that is an option. It should indicate the purpose, date, time, location, and title or position of school members attending. And parents are more than welcome to invite additional members to the meeting that they feel would benefit them. It's stated that they may request the local Part C coordinator to attend if desired. Some frequently asked questions in regards to special education. The prior written notice must be given with a change, if there is going to be a change, and identification, evaluation, placement, or educational services of a child with an exceptionality. If they are being proposed or initiated, parents need to have a prior written notice. If evaluation or reevaluation is desired, or if they are entering special education for the first time, or if there is a change in the frequency or placement, schools must request consent from the parent. The school must give notice to both parents regardless of their marital status. Only one parent is required to respond or consent. However, it needs to be sent to both if possible. Advocates must be 18 years or older, attend family training, and provide references from at least 3 reputable sources. The prior written notice is provided to parents before a change or initiation of a service, And a 10-day IEP notice is notice of a scheduled IEP meeting given 10 days beforehand. So those two things are separate. They're different. They're not the same. And services are provided from the ages of 3 to 21. Here are my references. And thank you so much for listening.